Someday you're probably going to lose a loved one, a mom, your dad, a sibling, or a spouse. And that's probably going to call for a trip to see the probate attorney, even if it's just for a consultation. So let's talk about what to expect, what to bring, what to be prepared for when you come to that meeting. First, and one that people often forget, is you'll need to bring the original last will and testament. I don't mean a copy of the original, the real original. And that's because in Oklahoma, if you don't have an original where the testator's hand and ink pen touch the paper, the court generally is going to presume that the testator destroyed the will because they didn't like it anymore. There are a couple exceptions to that, but they're few and far between. Generally, we've got to have the original will. Next, you're going to need to know the full names and addresses of what we call the heirs at law. The heirs at law are the people identified in the Oklahoma statutes to inherit if there is no last will and testament, or if the last will and testament is not admitted to probate for whatever legal cause exists, such as undue influence or loss of the original. So if it is a married couple with children, it will be the surviving spouse and all of the children. Not just the children that the testator liked, not just the children that stayed in contact with the testator, not just the children that you like. You have to list all of the children. Further, if any of the children are deceased but left children of their own, their children are entitled to notice, and so you'll need to bring the names and addresses of those people as well. We will also need to know where the person lived at the moment of their passing, or let me say that better. We need to know where they were when they passed away. If they were in a hospital, we need the address of the hospital, because under the law, hospitals have some special protections, such as being entitled to notice of opportunity to file claims for debts. They usually don't file claims, but they're entitled by law to get notice. All creditors who were either known to you or could have been identified if you did a reasonable search are entitled to notice. Now, you may not know all the creditors that first meeting, but bring the ones you know about and can easily identify. Next, identify the assets as best you can. And it may not be a perfect list. Some of you will not have been in close contact with the decedent's financial affairs during their life. Many adults take care of their finances right up until days before passing, and you won't know. But bring the information that you know. We are supposed to put into the probate petition our best information concerning the assets belonging to the decedent. We need that because the judge is obligated to consider a bond for the personal representative. A bond's a little bit like insurance against theft. So if the personal representative only knows about $50,000 in assets, we don't want the judge setting a $500,000 bond. Or vice versa. We want the bond and the assets to measure approximately equal, at least to the extent that the assets are spendable. We'll need to know whether or not you have ever been convicted of a felony. Felons are not allowed to be executors in Oklahoma. And I should explain, executors and personal representatives are different terms for the same task. If you are the surviving spouse and if you have been convicted of a felony, you should be prepared to designate someone else in your stead to be the executor. These are just the initial things that you'll need to know in order to have a profitable conversation with the probate attorney. And in our office, we've got a questionnaire that you can fill out on your computer. That'll get you a long way down the road towards identifying all the information you'll need for probate. If you would like a copy of those questions, call our office at 405 733 8686 and we can email that to you. Or we can print one out and you can drop by and pick it up. Just let us know which is better for you. Thanks, and I hope you don't have to face this problem anytime soon, but the chances are our time is coming to have to deal with the loss of someone we love.